Good evening. How are you?
Hi, Tom Burns. Attorney Nick Scoble. On the screen.
I, Dan Chevrolet.
I, Jake Valancourt. I, Dan Smith.
What great chair.
Thank you for coming in. I'm a new assistant ops manager for Life Plan. The assistant operations manager. Life Plan.
There you go. And this is the operational standard delivery here. And the light maintenance. And okay, this is our first meeting since the election, and what traditionally happens is we have a reorganization. I want to introduce Mark Cohen. Mark is a new light board member. He replaced Pat Cannon. I will entertain nominations for the chair.
I'll nominate you, Chair.
Second.
Okay, a nomination of Tom Burns, chair to continue as chair. Take a vote on that.
Aye.
Aye.
Aye. Aye.
Aye.
Okay. One down. Okay, our next order of business is nominating the vice chair. I will nominate Dan Ciccarello, vice chair.
I'll second.
The nomination for a vote.
Second.
Second.
Aye.
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 Okay.
So it passes 4 with 1 abstention.
4-0.
And the last member of our board is the clerk.
And nominate Jake Valancourt.
That's second. Okay. Have a vote on that.
Aye.
Aye. Aye.
Aye.
Okay, so.
I make a motion if we approve the minutes of April 28th. Meeting. Open discussion.
Mr. Chairman, if I may,
Sure.
as the minutes reflect, under item 3, I would request that the board make the edit. One, I was not the prior grant writer for the CZM coastal grants and didn't simply decline to attend the meeting after consultation with council. Neither myself nor the operations manager were at that meeting, which is not reflected in the.
What was the last meeting?
That neither myself nor the operations manager were in attendance in that meeting after consultation with them.
Oh, you want that to,
It just talked about the town manager. And then I declined.
you want that phrase to be in there, or that phrasing?
What, number 3? 4 now? No, this is a good question.
I think number 3, discussion, commitment to non-court continuation with the.
Is that the one you're talking about, John?
Yes.
I see that as a friendly amendment.
As the prior grant writer, who was the grant writer?
I believe Chris Craw first was the grant writer.
Okay.
It was not me. So I think it just be
Whoever it was, it was me.
exactly.
would it be simpler to leave Chair Burns open the discussion? And basically take from as the prior grant writer, strike that down to the town manager was not in attendance, I'm adding that, and then leave the board therefore proceeded with the discussion in her absence, so you'd be cutting most of it out. Does that solve the issue? Then we're not talking about who the prior grant writer is or anything like that.
So we read Chair Burns open the discussion period.
And then
The town manager, no,
Just have the town manager would. Now we expect it.
Take all that out, you already noted that I was absent. At the start of the minutes.
yeah, I mean, I see the point.
So those
So
first,
Chair Burns opened the discussion period. The board proceeded with the discussion and town, light board absence.
and everything else is cut.
Yeah.
From that paragraph.
Actually, that seems appropriate to me.
Other minutes. Oh, you already made a motion to.
Yeah, I read about you, do pending discussion.
second motion,
Right, seconded by Tom.
so. Any further discussion? Right. Can start on the left. Steph, I always start with you, should I start with Jake first?
Okay, aye. This is to approve them as amended?
Yes.
Yeah, okay, aye.
Oh, I'm sorry, wait a minute, I have a couple of questions. I thought you were just approving what we just made changes on. No.
I looked at that, I love it. It's right in front of
I'll hold my vote then.
Yeah,
So hold off a minute.
I have a friendly amendment.
Questions on the second page and. Does Commissioner Valencourt further stated that the CFM Coastal Resume Grant Program requires letters of support from all relevant boards and commissioner awards, and that no such letters of support was solicited from or provided by this board? Can we confirm that this requirement?
It's on the CCM website, that's what I stated, whether the statement stands, even if I was incorrect, I don't think I was, but my statement's not changing. Happened, so I'd like the minutes to reflect that that was my statement.
Yeah, I mean.
I guess I'm just asking, I would like to, I mean. Your thing was on the coastal zone management website.
It is, I mean, if you want, I can take a minute to pull up the website and show you the link now.
In the paragraph before that, he stated that in December 2025, the board voted. Both opposed the relocation and firmly directed for the correct, blah, 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 blah. Can you see that though? I couldn't find that in our minutes. I couldn't find that anywhere.
So there was discussion in November and. I don't remember, maybe October, but definitely November and December. We took a vote in December. I think, I don't have it in front of me, but I think the vote was advising the light plant manager to instruct
I
boarding around.
just couldn't find it. I'm just asking, through all my minutes that I have, and I can't find that.
That was my memory, but,
Yeah.
there's.
I know we all agreed that we were opposed to it, I'm just saying, I don't remember the vote, I couldn't find it in the minutes, I didn't see about it.
The discussion was opposition to a joint facility, but the vote was not. The vote was very clear, what I remember was to build. Or maybe around 15. I don't know exactly how it phrased it, that's what the vote
See
was.
that in our minutes, I can't find
Well, there's.
You mean the previous minutes or these?
the previous minutes, I
Okay.
couldn't find. That's all I'm saying. I mean, when I read this, I look back and I think, okay. I know we discussed it. I'm just looking for a copy of that vote in our minutes.
Okay, it would definitely be in previous minutes, not
Right,
the.
absolutely.
So I
That's what I'm
I think
saying.
these minutes in this paragraph are accurate. Because it's what we discussed. Yeah, in, what was the date, April 28th, exactly what date the vote was taken in December, I don't remember, but. These minutes are meant to reflect what happened on April 28th, not that, and what happened on April 28th, we talked about what our recollection was in
Mhm.
various ways. From the votes in 2025, but I don't think we need to.
I think there's two issues. The first one is whether or not it reflects what was said as opposed to what is true. Right? So I mean, those are two different things in the sense that if I say we're living in Russia and it reflects that in the minutes, it's only reflecting what I said, not necessarily what the truth is.
Yeah.
So if you wish, perhaps what we should do is just put a little asterisk there saying, you know, that it's the
I guess I'll.
Accuracy is
I just want to see the vote. I like to have my minutes and my paperwork kind of all in order. And I'm not opposed that we voted. I'm just saying, I don't have a copy of it. I can't find it anywhere. I'm not saying it didn't happen. I'm just
You
saying,
should what you're saying.
give me a copy.
I'm just trying to see if we can get the minutes approved. If we have like a little asterisk or an asterisk saying, and that this is the accuracy is of that statement is question. That okay?
What do you want the asterisk to say?
Um. The accuracy of the statements. And.
I think. No, I'm not really okay with that, it's what we discussed and it's what happened on April 28th, I don't think. Putting an asterisk in there of the accuracy of the statement is in question. I don't think that's how minutes are supposed to work, it's what was discussed.
Well, then I think, all I'm saying is I think that a copy of that vote should be in our previous minutes if we voted on it like you said here. I remember the discussion. All I'm saying is I can't find that we actually did a vote on that. We discussed it, but I'm just saying if we voted on it, it should be included in our minutes.
Sure.
We would go back.
Yeah, we would go back to November, December, maybe even having to look at October to see the full span of the
I
discussion.
looked at what I have for copies of December, November, October. There's nothing on the website, it's what we have. I'm just saying I would like to just see it, that's all.
Okay.
Make a note of that.
So I'm gonna vote on this motion.
Yeah. Let's have it moved.
Okay, so Stephanie, it's the November 20th minutes, I just pulled them up, do you wanna read them?
November 20th,
Yes,
okay,
so I apologize, I thought it was December. I misremembered, it was November, do you wanna read the motion that's in our minutes?
Sure.
Alright, there's two here, let's see. We did a lot that meeting, so motion garage, a motion was made to propose a capital project to fund a garage at 15 Edgewater Road. To store fleet vehicles designed to allow for solar orientation and complement the historic nature of the existing building, vote unanimous in favor. I didn't produce a certified vote for this one, so that's all we have, that was November 20th.
okay.
And
Thank you.
it's under two. And it's under FY 26 budget and capital projects, and it's the only capital projects vote taken, that's it. But I don't wanna change the minutes because it's what obviously memory's imperfect for all of us, and my memory. On April 28th was that we took the vote in December, turned out we actually took the vote in November. Still took the vote. So I don't wanna,
No, I.
My portion of it is
I
all
agree.
right, yeah.
I think Dan brings up a good point. It's what we discussed
Yeah.
on the 28th. Whether,
I'm happy to reflect it in this meeting's minutes that Commissioner Valancourt has a crap memory for that.
Just put under the discussion in the minutes, it was determined that. The statement, the.
should we change to Sunday?
We changed some.
November.
Statement made on April 28th should be changed. From December to November, okay. 13. Done. Got any other-
Anything else?
No.
Now, move forward. You made a motion, and I
seconded it.
I seconded it.
Yeah, it was an amended motion based on what the like my manager had asked. Or
And this,
had
and
suggested,
this
it was
additional
it
motion.
was a friendly motion, I made friendly amendment. I did answer your question.
Hi, Jake Kelly.
By Tom Burns.
Work coach.
And Stephanie Lynch.
Hey, next item. Item number 5. Section 5, Green Accounting as a resolution. Which was read on April 28th. I believe the whole resolution is contained in the minutes. Like, the deal of the minutes. And as we get into section. One, formal opposition, withdrawal. Communication, no state agencies. Referral to Mid-Life Plant Resources and Supplies of Fuller County. What we have is section 5 of Fuller County. We read this. Receive a review of the written accounting due to the light board at this meeting under section 5 of the April 28th, 2026 resolution covering 1. Town grants since 2022 related to HMLP property operations or the joint facility concept. II. All municipal light plant resources committed or expended in connection with such grants. III. Scope of work and design completion targets for phase 3 grant, many pending or submitted phase 4 applications. 4. Town communication with CZM. Economic. Executive Office of Energy and Environmental Affairs. Or other state agencies representing or implying all municipal light plant support and consent or participation. And 5, confirmation of any phase 4 application submitted on or before March 27th, 2026, including amount, scope, and any representation by the whole municipal light board, light plant board board support. Okay. So. This would be, I would say, directed to the person that submitted the application. Would it be the town manager or the light plant manager?
I took the application. I think we addressed the issue or questions relative to CZM, and as the board knows, there's a presentation being presented next Wednesday, June 10th, a joint meeting with the light board and the select board to provide an update on the season.
Great, that's, I knew that you were trying to do that. And this is Weston and Sampson will be here to give a presentation.
There'll be a variety of combination of consultants and staff.
Okay. Is it by saying that we would assume that most of these questions could be answered at that time?
Yeah, I don't know about a full accounting. I'm not sure what a deficiency therein refers to. But we can certainly provide updates on applications submitted, the status of the project. We're not going to get into details on specific emails between variety of staff and consultants. I know we have Attorney Scobo with us this evening to maybe touch upon the project or the resolution and the validity thereof.
We could do that before we go to Attorney Scobo. Are there any other internal questions?
So is it, Jen, are you confirming that we're not receiving any of the information requested in the resolution
I don't have that information this evening.
but will it be provided?
Yep, I will see what's provided next week at the presentation.
All right, noted. I'll put it in the record.
Okay. Mr. Scobo?
Yes, I don't, the gentleman to your right, Tom, oh, thank you, because you were blocking the view with the back of your chair.
My big head.
With respect to section 5 of your April 28th resolution, I have spoken to town council. I've spoken to,
Nick, I'm sorry, can you either speak up or maybe a little closer to the microphone? It's just a little, I have you up pretty high on the volume here. I'm not sure there's anything you're doing on my end.
can you hear me?
We can hear you.
I don't know what to do. I don't know if you,
Sorry?
I think if there was only 78, it should go to 100, right?
Yeah, it's not gonna make a difference.
can you hear me now?
Well,
Not much louder now.
okay, the volume, I think we're about as loud as you're gonna get.
Right. I don't know. This is, I can get a little closer. I don't know. I spoke to the town council. I've spoken to the town manager and manager of the light department, and I've spoken to the chairman of the board and the clerk with respect to the wording of your section 5 of the April 28th resolution. And to make a long story short, I think you exceed, the board exceeds your authority to, as you put it, direct the town manager or the manager to provide this information. Under either chapter 164 or under the town charter, I don't think you have that authority. On the other hand, as I spoke to all of you about it, you can certainly ask for that information. You can certainly either do it as a public records request or in some other fashion ask for it. But the way it's worded, it goes beyond your scope and goes beyond your ability. Uh, you don't direct the manager to do that under either 164 or under the special act. And I've explained that to all of you.
Nick, is it fair to say that the other four sections before five in that resolution are valid then?
Um, let me go through them real quickly. I think number one is perfectly valid. The board has an ability to present or state its viewpoint. Uh, Number two is the same thing. I think it just clarifies the action of others and so on. Number three, let me just quickly read it. Provides direction to its own clerk, and the board can certainly do that. Number four, uh, to the extent by section 4 you purport to engage in the operation and management of the plant, it's a little iffy in number 4, you would then exceed. To the extent section 4 only provides the board's direction regarding the use of HMLP resources, then it would be consistent. It's worded a little oddly. Okay, I think most of it is okay, number 4, but not all of it. Number 5, we talked about. Give me 1 second. Number 6, I think it's just reserving the rights under general laws, chapter 164, and that's okay. There's no big deal about that, one way or another. Number 7 is consistent with the board vote. Put my window open, things are blowing here. Let's see, about being public and so on. And number 8 is the board's prevents the board from deciding when the town votes take place. So holding chapter 164. Okay, so I don't think that's an issue. To the extent that number 5 is invalid, it doesn't invalidate the rest of the vote of the resolution. And there's some, legal standards for that. I am looking at it as each vote is separate. In that regard, I would urge you to change your voting system. Okay. That means you would vote, each vote would have its own number. For example, this wouldn't be a resolution with 5 parts. The first part would be vote 26, meaning the year, -2. The next one would be, 26-3. That way it's very clear. I've done that with every single board, and I would urge you to change your voting to that effect. You follow what I'm talking about? So
I
you
think so.
don't
Are you
have,
saying that for all votes, not just this resolution?
say that again?
Are you saying just for this resolution or all votes going forward?
Going forward. Going forward, have each vote numbered separately. Like 26-1, 26-2. That way you don't get into any kind of ambiguity and issues. With respect to this resolution, I took each one of those, 1 through 8, to be separate votes, thereby not because they're not interrelated to each other. They don't, one is not dependent on the other. I mean, it's clear what you're trying to do, but they're not interdependent on each other. So invalidating number 5 would therefore not invalidate 1, through 4 and 6 through 8, because I would consider them separate votes. And in order to make it clear and clean, I would urge you in the future to do it the way I just suggested. It makes a lot more sense.
Nick, can I ask you for clarification on number 2? you said it states in there, any representation of home municipal light plant support made to the Commonwealth, to any state agency, or to any consultant is hereby disavowed. If the board chooses not to support the project, that's one thing. But the department and their participation in the process is wholly separate.
I think, you know, it really is, it's clarifies, in my view, the action or inaction of others regarding the proposed joint facility or the grant application therefore does not represent a board's position. There is nothing in 164 that prohibits the board from doing that. Okay, I don't think it's that. Basically, you're saying that, you know, the board, the town employees, any consultant, blah, 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 shall be construed as representing the support, endorsement, or consent of the board for the joint facility, not the light department, of the board. So the board's in number one says we don't want it. Number two, any action by anyone else shouldn't reflect and degrade from the board's first vote, which is we don't want to do this. I think that's fine. I don't think that's an issue. But I do think 5 is beyond your scope.
Okay. Thank you, Nick.
You're welcome.
It would appear that, but the light plant managers indicated that, most of this will be discussed again on the 10th. And we can review these issues again on the 10th by whoever's here, whether it's Weston Sampson or additional staff that they bring. And then we can revisit this. And make a notation about, number 5, and that we are not demanding that this be answered, but mainly that we request an answer to section 5 or part 5 of section 5.
I mean, I may ask, while we have counsel here, just in full transparency. And as it relates to the upcoming meeting on June 10th, Nick, if you could speak to the board's authority relative to the building and the project itself.
I'm sorry, what's the question? I'm sorry.
The question was if you could speak in advance of the June 10th meeting, and I believe Nick will be there also. You can speak to the board's authority relative to the property and the project itself.
Exceeds the board's authority in the property. I don't know if I go that far. Number 5 certainly exceeds the board's authority to direct you to do those things, to give them those things. I don't know if that then translates into, you know, not doing the building or anything of that sort. I think they're two different things.
The building is town property.
Chair, can I ask a question to the?
On town property, it's owned by the town, there's no doubt. The building where the light department is owned by the town, there's no doubt. However, at some point in time, God knows when, the town gave control of the property where the light department is located to the light department.
That's not accurate.
I'm sorry?
When you say control to the, that's not accurate. It's a town-owned property. It's under the town's.
I will tell you that every single light department that doesn't own property, and I can think of some that do, and I can tell you that even then, when there was property taken by a town, that town ultimately voted to give control of that property to the light department, etc. right? That doesn't mean that they can do anything they want with it. It doesn't mean that they can sell it. It means they use it. What I mean by control, they can use it. That's what the town is saying. If they don't use it, if they want to get out, they got to go back to the town and say, okay, we don't need this for our purposes. And the town then has to see if any other department can use this property, et cetera, et cetera. But at some point, the town had to say, this is for you, you can use it, you can control it. But they don't sell it. They can't just do anything they want with it.
Are you saying that as long as we use it for the function that it was intended? That
Yes,
we could operate at that property?
yes. The property you're in, what is it, Edgewater Drive
15
or
Edgewater.
Edgewater Road? Yeah. Yes, that's exactly what I'm saying. Right now, look, the town owns the property, the town owns the light department, the town can sell the light department if it wishes, and it can sell the property if it wishes. But the utilization of that property is for the purposes of the light department's or light plant's purposes. The light plant can't go to the police station and use that, can they? Nor can the police station come to the light plant and use that.
But the light department also can't, or the board can't alter the building or relocate the building without the town's permission, because control of the building was never.
If the light plant if the light plant was going to refurbish that building, you'd have to get permits, you got to do, all that kind of stuff, no matter what. And they don't just do it. It's like anyone else. They have to get permits to do so. And they'd have to justify it. And then you boil down to how do you pay for it in any kind of construction or renovation.
Nick, I
If-
think our conversation is getting a little bit out in the weeds. This might help clarify. My understanding is that right now, without chapter 40 being implemented, what we all have to live with for now, the light board is, as a board, only 5 voting members, controls capital decisions, right? But the
Wait a minute,
light
wait a
plant
minute. That's
manager
not the
controls.
Wait a minute. That was not the question asked. Don't change the subject. The
I'm not trying to
question,
change the subject. I'm trying to clarify by asking a different question.
no, that's a different question. I was going to clarify I didn't finish my clarification about
Sorry,
whether the town has can approve it or not, or whatever. I said the town certainly has to approve permits to the extent that the construction of or renovation of a building, you're going to, if money borrowed, if the town is going to borrow the money and have the light plant pay it back, which happens, then the town, then you got to go to the town for that approval. On the other hand, as a member of MWEC, if the light department wants to do that, once they get, meaning renovate, once they get the permits, et cetera, they can borrow the money from MWEC and not affect the town and not have the town borrow it. In addition to that, and I'm telling you, I had a conversation today with South Hadley on this very point. In addition to that, there are funds that the light department holds. You got a depreciation fund. You've got probably some reserves somewhere at MWEC. I don't know if you do or not, but you definitely have the depreciation fund. So the decision has to come down to how much are you willing to uh, put up as a capital addition out of your cash on hand, and how much do you wish to borrow? That is exactly the question I had today with South Hadley. Exactly. And they're building a building. South Hadley Light Plant is going to build a building that's $36 million. That's exactly what we're going through. So to getting to your question, Jake, who has control over those funds, right? The depreciation fund or I don't know, if you have a reserve. I don't know if you do, but I'm going to assume you
we
have
do
some
have a
kind of,
reserve held at MWEC, yep.
yeah, okay. I assume that. And what I told South Hadley and what I will tell you is I got to look at the trust for that reserve. And the decision and the issue with South Hadley was, can the board simply access it, and or can they direct the general manager to access it? And I said to them, and I will do it. Look at the creation. In fact, I created them. I don't remember them how we did it. Who has the as the grantor of who when they're putting the money in, who has that right to put it in and who has the right to take it out? I don't remember. So that has to be looked at. With regard to the actual capital, right? Certainly if the right exists for the light plant to take the money out, the question then is who? And you probably would have some form of vote to use, maybe if you want, I don't know, capital for capital additions and borrowing, whether it's from MWEC or whether it's from the town. And the town may require you, if they're going to issue debt, to use some of your money. That's going to be a financial decision that comes down to what are you earning on the return versus the cost of borrowing. And that's really what it boils down to, doesn't it? Isn't it?
So. Right now, the line of authority, as I understand it, right, the light plant manager brought what was it, 250th celebration request to us. I viewed that as like a pilot payment. It was $25,000 one-time donation. Ultimately, it's going to be recorded as the pilot payment. The light plant manager, town manager had to bring that to the board and get a vote because it's not in the normal DP. It's not operational spending, right?
Yes, we talked about that. We talked about that today, and I'll repeat what I said and today to you and Tom. The town manager, as the manager of the lighting plant, has control over the operations of the light plant, right? And those operations would include, expenses and all that kind of thing. The accounting for the light department operations is dictated by the Department of Public Utilities. I do not know of any account where you could place $25,000 as an operating expense of the light department. Consequently, that means if there's going to be a donation, it is a what I call a below the line item. It is in an unappropriated earned surplus, which is where you also get the funds for the pilot. In other words, it's after the operations. It's what's left over after the operations. So it would be to the extent that the town manager and or the whomever came to you and asked for a donation, it would have to come out of those funds, which is in the nature of a pilot payment. So sort of the same thing. So, and that's where the funds come from. They're not operating.
And for clarification, Jake, the 250th committee requested the funds. They asked for a donation from the light department, as they did with other boards that requested not come from the town manager.
Okay, my understanding was they requested it to you, and you said that has to go before the board, and that's why I can't.
It's to be on the agenda.
Okay.
All right. We've been talking a lot about, and I'm just going to blurt it out here because, there's been a lot of, and I've been involved in an awful lot of discussions. Who has control over this and who does that and so on. Those questions, and I called it ambiguity, results from the manner in which the 1993 Act making the town manager the manager is worded compared to 164. The town knows that. The town voted to repeal that 93 Act. All right, it's got to go to the legislature. Whether the legislature does it or not, who knows? However, between now, in fact, last year when when the town voted, and now and going forward, you got to live with what you have. You guys have to work together as opposed to who controls what and who is going to tell someone to do something and not do something. You got to work together. And I'll tell you, it's for the benefit of the ratepayers. That's what you raise your right hand and swear to uphold, as does the town manager in a sense. But it's a public entity for the benefit of the ratepayers. And this kind of infighting and control, I don't see that benefiting the ratepayers. You've got to live with what you have until it's changed. And it is what it is. That's why, for example, you know, opening up a dialogue with the selectmen in terms of a building or use and all that kind of stuff makes an awful lot of sense to open up a dialogue. That benefits the ratepayers. That's what you're there to do, as opposed to spending public money fighting. Makes no sense. That's not what you're there to do. You got what you got. You got to live with it. It's important that people understand that. At least that's my view of it.
Definitely, the select board is the one that, appoints the town manager and in effect, the light plant manager, not us.
That's
And
correct.
I definitely agree that one of the most productive conversations we'll have is with the select board on the tenant. And we'll be able to,
Well, I'm not really saying that. What I'm saying is because the select board appoints the manager, and it also says, and under 93, I mean, the Act of 1993, it also says they have to act, that the manager has to act in accordance with 164. All right, 164 says that the manager operates the light plant under the direction and control of the board, the light board. There's been an awful lot of case law on what that means. 93, the Act of 93 says that the light board can give general guidance or something to that effect to the manager. Guess what? The courts have interpreted 164 to say the same thing. All right. So you've got to reconcile that to the extent that one board who is looking to, meaning the select board, is looking to perhaps, and I use the word perhaps, spend public money to construct the building at whatever dollar amount it is. And the light board, in its responsibility, doesn't think that it should be a part of that. Then you then talk to each other to try and reconcile that. It's not talking to them to get the manager or to smack the manager. It's to resolve the issue. That's important. That's a distinction that I think you have to have. That's your obligation. And that's their obligation. And the reason is you got people sitting in the room that are paying the bill. They're paying the bill on taxes and they're paying the bill on rates. It's important that you guys work together. I don't know how else to phrase it. I don't know how else to be clear. And I believe this in deep in my heart. It's very, very critical. And you've got to live with what you have until it's changed. There's no doubt that the town wants it changed, but you got to go through a process to get it changed. I don't know how long that takes. Obviously, the first vote, the legislature tabled it, right? It D6'd it in a committee. Now you have a second vote. You haven't gone, not you, but the select board hasn't gone to the legislature yet. All right. So it's going to take time. So what happens in the meantime? You fritter away your responsibilities? I doubt it. It seems to me you got to work together to solve your problems. That's important.
So Nick, can I just ask a question, and this is the confusion that I'm having? I'm looking at chapter 93.
Yep.
And I'm also looking, this is an issue that has come up before, and this is nothing new. And I'm also looking at the letter in 1994 that town council wrote explaining that the authority of the light board now would be to set rates and advise the town manager on general policy.
Correct.
And in that umbrella, there is so much that we can do. Like
Yes.
the third feeder line. I mean, there's so many issues that we could be working on. I think we're not wasting time, but I don't think it's appropriate at the moment to be working on this resolution that really, like you said, I mean, 5 is way out of our scope. We already said that we did not agree with merging the light department and the highway department. Panos called all of us and asked us. He was our operations manager, so we took his expertise and knowledge, and he came to us and said, would you please support me? I know what I'm talking about. I'm managing the light plan. So we said, okay, Panos, we'll support you. Panos is gone. We have a new operations manager and an assistant. They've never said anything to us. They've never asked us as a board. We're basing a decision on something that a previous operations manager asked us to do. My opinion is not my fight, not my issue. I think it's an issue that belongs with the professional operations managers and the light plant manager. And I, as a board member, think that it's their issue, not mine.
I don't think you're correct. I think it is your issue. The reason why I think it's your issue under that 1993 Act or under 164, under 160, either way, you are obligated to give general direction to the manager of the light plant. Okay, and if, in addition to that, if you feel, how do I want to phrase this? If the operations manager or whomever, or an engineering firm, I have no idea, whoever says to you that we think it is better for the light plant to protect its assets. I know you bought a truck or something and it's coming. Then it's your obligation to protect the ratepayers and take that information and deal with it.
Right. I don't disagree, Nick. Let's use that truck. I didn't buy the truck. I mean, we were told they needed a truck.
Yeah.
But I wouldn't have bought a truck if I didn't have a garage to put it in, Nick. So now we have a problem that we've got a truck coming. We have no garage to house it in. Does that mean that if it has to stay on the elements, it's not gonna be under warranty or guarantee? I don't know.
That's a big issue. And that's why I would say to talk with the select board, because you have that opportunity, and you just say, you may determine, look, we are in charge of overseeing the assets, etc., of the light plant. We bought a truck, not the town. We bought it, paid for with ratepayer money. Is it owned by the town? Yes, but it was paid for with ratepayer money, not taxpayer money. All right, and that's a clear distinction in the law. And in order for us to protect that asset, we believe that, we need a garage or we're going to do whatever. And you're going down the road, select board, and not unreasonably of building a bigger building. Perhaps we shouldn't be part of it. Perhaps in your deliberations on this, that maybe it should be downsized because we can handle it ourselves, you know, under other laws. That's what I'm talking about in terms of fulfilling your responsibilities and fulfilling theirs. If I'm a selectman and then town manager comes to me and said, "Hey, you know, I can get all sorts of grants to pay for a whiz bang building, and we can consolidate." I'm all for it. I want to see what it is. I want to see how it happens. I want to see whether that works or not. If I'm a selectman, makes all the sense in the world. You know, that's not an issue. However, now you have a independent, not independent, but a department of the town that has independent money from the town saying, you know, I'm not so sure that that would work for a joint facility. And we need to talk about that before you go, you know, way down the road and spend money designing this when you could spend money designing this or something. That's really what we're talking about here, as opposed to, you know, the town manager didn't answer this and didn't provide that and didn't do this and that. Yeah, it's ridiculous. Work together. You have to work together. That's the way I see it.
So Nick, the um, responsibilities of the town manager is to protect the taxpayers' interest. And the interest would, right now is a new DPW garage. And we, as the light board, have an interest in protecting our asset, a truck and our other vehicles. And we want to build a garage to protect the ratepayers' assets. Normally, the light plant manager would concur with the light board.
Not
No?
necessarily.
Okay.
And one of your premises is not accurate, Tom. The town manager, yes, looks out for the taxpayers. The town manager, by statute, also is the manager of the light plant and has the responsibility to look out for the ratepayers as well. All right. It's not just the taxpayers. It's also her responsibility is both because the town voted to give that to her and it passed the legislature. That's what the town wanted. Now you got it. Now you got to live with it. Okay.
Right.
And then the town wants to change its mind. It says, you know, that may have worked 30 years ago, but in today's world, yeah, I'm not so sure we want that. So they vote to rescind the 1993 Act. Nothing wrong with that. But that responsibility that Jennifer Constable has is not just to the taxpayers, it's also to the ratepayers. You don't have responsibility to the taxpayers, you have responsibility to the ratepayers.
Right. And if we see that spending $1, $2 million, $3 million for a garage and an upgraded facility at 15 Edgewater would be better serving the ratepayers. And if the light plant manager / town manager sees that a joint facility, which will cost $45, $50 million, would benefit the town, I could see that a considerable amount of debt to the ratepayers. So
All right, I'm not sure I don't know if you're there yet. Okay. I know it's been talked about. And that's why I urge you at your June 10th meeting to talk to the select board and say, you know, as you plan this, you know, we have this responsibility, you have that responsibility. And as you plan this and direct the town manager to execute the plan, whatever it may be, we think you need to take into account that we don't think we should be part of it. Because number one, there's some benefits. You got to look at the cost benefits. A selectman may say, yeah, but look, it saves everybody money if there's a joint building. All right. I don't know if they're going to say that. I don't know what the thought process is. But, this gets to this notion of who controls whom and what. And I cannot say it enough. You gotta work together. You have what you have. And you gotta work together in this transitional period, number one, and you don't know how long it's going to last. You don't know. You don't know what the legislature is going to do or not do. In the meantime, you got an asset coming in, you got spending money designing, you're spending money doing all sorts of stuff. Now, wait a minute. Let's think this through a little bit. Let's work together. I don't see why you can't have I'm making this up, a joint committee with the select board to look at this, and with the whomever the hell you deal with. I don't know. I don't know what the select board wants or not. I'm going to be at that June 10th meeting. And if I get the opportunity, I'm going to get on the pulpit and preach like I'm preaching now. I'm sorry.
No, I'll make every effort for you to educate us.
Well, I feel very strongly about it. I've done this for 45 years. And I've seen an awful lot of, fights with, light departments and managers and, the boards and all that kind of stuff. You're in a unique position. I don't know of any other light plant that has the exact type of setup you have. And maybe it was needed and worked in 1993. All right. Maybe that time is over. So now you got to work. You got it. Work with it until your transition occurs. And if it doesn't occur, you got it. You got to live with it. So deal with it. That's kind of the way I see it. Um, you know, and I want to be also one final point. I do not represent Jen. I do not represent the light board. I don't represent Mike. I represent the HMLP as a whole. And that's where I'm coming from. That's that's something you should really understand. I think you understand it, but I wanted to make sure that's clear. And
Yep.
under 164 and under the 93 Act, the manager hires lawyers, not the board. That's just the way it's set up. You know,
I don't have any questions.
thank you for letting me get on the soapbox.
No, I think you've clarified a lot. Right. I'm not gonna take any questions. There'll be time for public input. Will you be around for most of the meeting?
Yeah.
Okay. At that point of time, I guess have we, set up? Do we need any further discussion on item 5? If not, you'd happy to go to item 6 on the agenda. And it's a good thing you're here, Nick. This is regarding independent counsel. This is a discussion and possible vote regarding retention of independent legal counsel for the board, including possibly request to the select board under whole town charter section 3D for appointment of special counsel. And B, Attorney Scoble may be present for board questions about his role and representation on possible disputes between the light board and the light plant town manager. So this, this item, this discussion, is to determine whether the select board could engage independent counsel to resolve some of these issues. You being here, I don't know if you just answered the question 3 minutes
can
ago.
answer.
Sure.
I'm not fearful of jumping in. I don't think that the select board can obfuscate the chapter 164 and or the 1993 Act, which says that the manager hires attorneys under 164. Okay. And I've dealt with it many, many times. The light boards don't have the authority to do that. The question is whether your special act, the 1989 Act, which has started your charter, whether that section which allows the select board to appoint special counsel, I didn't weigh in on. My view is they can't do it on, because it's in opposite of 164 and the 93 Act. However, town council may have a view that because, and I'm making this up, I haven't talked to Brian about this at all, may have the view that the special act trumps the general law, and under section umpty-ump, whatever it is, under the 1989 Act, the select board can appoint special counsel, and this is one of those instances when it would exercise that authority. And I don't know, but that is a question for him. As for it just standing on its own, I don't think they can do it under 93 Act or under 164. I think it's opposite. It's in opposite of both.
So, Nick, is it fair that or I shouldn't say fair, when there's a dispute between an elected light board and a light plant manager in general, and the board wants independent counsel that only represents the board, how do they obtain that? Do they ask the light plant manager to go out and shop for them?
Yes, they asked the light plant manager to exercise the authority to obtain a counsel for the board. The only times I've seen that over all my years, the only times I've seen that, it's not in this type of circumstance, but frankly, when this is a little dicey, when a board member of another board used his position to have an affair with someone that worked at the light department and used light department facilities. And he and the individual, the woman, sued him, sued the board, sued everybody in sight. And the manager did get a counsel for the board because of this kind of rogue commissioner, his interaction with the board and what he did. I represented the light department in that particular matter. That's like the only time I've seen it. But under the 164, a manager could hire an attorney to represent the board. I don't know why you need it. I don't know why you want it. Again, that's sort of like who's in control here. Well, and we don't like the way it's running, so therefore we want to hire a lawyer to advise us as to how we can do this. I go back to what I said earlier. You got to work together instead of fighting. That's just more public money being spent. But, Brian Winter may have a point of view that the 1989 Act, your charter, can allow the select board under certain circumstances or whatever, I don't even know what they are, to do that. And it trumps 164. I don't know. I have not talked to them about it. But, you know,
All is special, it's one of one, isn't it?
sorry.
Hull has a unique charter, no other town has, so the question may never have been asked, right?
Not that particular question, because there's no town charter like that in any other. But and what I'm trying to tell you is if let's go to a town that doesn't have that type of charter. So therefore that question couldn't be asked, right?
Right.
Okay. And it would fall under 164, right? Okay. And you know, and you agree with me, don't you, that the manager has the ability to hire attorneys, not the light board, right?
That's exactly my understanding.
Okay. So therefore, under those circumstances, that's my view, right? That's what I'm articulating here. You have a unique situation where your town charter says the select board can appoint special counsel for departments or whatever the heck it says. So you're right. It hasn't happened to my knowledge. I don't know of any town charter that has that. Maybe there are, but I haven't seen it in my experience. So therefore, it's really a question of the town council. And I would tell him my viewpoint on the 164 and the 93 Act. I don't know what he'd do. I don't know.
So, Chair, I'd like to sort of make an overarching statement that encompasses what Stephanie's talked about. But I can only speak on behalf of myself. I can't speak for the agency. So, for Stephanie, I've talked with Mike. I know you know that we've all talked with Panos.
Yeah.
And I think you know that we've all talked with a number of other light plant managers and also light plant operations managers in other towns. About various things, batteries, sharing the facility. So I've sought the opinion of many light plant managers and I'd say less, but at least 4 or 5 different operations managers at various light plants throughout Massachusetts. And I've talked with fellow commissioners in, I want to say 8 or 9 different municipals now. And everyone has told me that a shared building for the light plant will have operational challenges. Different managers from different geographic locations have given different reasons, but they've all come to the same conclusion that it will be a difficult thing, and if they were the manager, their choice would be not to do that. So I wanted to acknowledge that because you earlier had said that none of us have consulted Mike or.
I didn't say none of us had consulted Mike. What I said was, Panos went out of his way to call us individually to ask us to support his decision in not merging the two.
Sure.
Mike's never called us, and I have not called Mike. I haven't called that. I guess in my world, Jake, the operations manager is the professional person that's hired to run the municipal light plant. I believe that part of their job is to work with the light plant manager to convey to the light plant manager their position. They've asked us for our support. We've given it, Jay. I think we've done our job. I think the issue of merging these two now lie with the professionals that know the workings of the light plant for better than we do.
That's where you're
That's my-
disagree.
Yeah,
Yeah.
I disagree with that.
Yeah, I think that it's the light board's purview to sort of set policy, and here's why I disagree on that particular part of it. We agree up till you get to there, then we disagree, and there's a why, or diverging opinions here. And mine, and I'm not speaking for Dan, just me. It's pretty simple. I look at it as Right, I don't think any of us actually look at, we wanna deliver the lowest price possible for the ratepayer, we wanna deliver the best value, so that means. We're willing to pay a little bit more if it means our electricity is reliable, right? And I don't think anybody's gonna say that's not a sound position. But where I'm going with that is in delivering the best value for the ratepayer. Given the stack of capital projects that this light board has been told is coming. Feeder line, whatever you wanna call it, lump it in, capital projects, it's big money. We're gonna have to spend it someday, whether we like it or not. Given that, and given the costs that we've only been given preliminary cost estimates on. The combined proposed facility, and we've only been given very preliminary cost estimates. On renovating in place and erecting a 4-bay garage, so we haven't been given a final answer, but. Based on the preliminary data we have so far, so what we know right now, the best decision we can make is to totally oppose. The combined facility, because that will cost the ratepayer substantially more, even if we only paid for a third of the building. Of the combined or the new building that would combine the two departments, if you have that. I still say that, say it's $50 million and a third of it, that's a lot more. Cost for the ratepayer and a lot more inefficient. Than to simply renovate what we have in place and make it work. With a 4-bay garage and whatever our renovations are, so I'm looking at it from that perspective, and that is our elected duty. To look out for the best financial interests and other interests. For the ratepayer, and that's where my position's.
But I think we've done that by supporting the operations manager's request of us. Now I think it's the operations manager's job to now present the facts and the figures to back up why we're supporting the operations manager.
So I agree that it's the job of the life plan manager and the operations manager to provide us with the information, but neither of them are policymakers. That is the light board, and I view this as a policy decision. It's a capital spending decision, and to me, capital spending is the most germane thing
But
that is
we are
policy.
advising, EJ. That's our job. We are advising. We've taken a position and we've advised.
Right, I'm going a step further. I'm saying that it's not just advising. We would need to take a vote. Say we were gonna. Say Mike and Jen had a proposal to build a new feeder line, and it was. Pick up a number, $30 million, I don't know, let's say that was in front of us, they can't spend that money without a board vote. Because that's capital, that's different bucket. That would require borrowing, given our position. So would this joint facility. This is not operational, and my understanding. And I understand Nick has said many times it's complicated, but chapter 164 and weave our special act town charter through chapter 164. We still have the authority and have to make the policy making decisions that are capital spending. And that also includes anything that would be left over after we've done the operational side, aka pilot. Whatever you want to call the donation to the 250th celebration, all of that would be on that side. That's how I view it, and if my interpretation is incorrect, I'd love to hear from Nick Scoville, but that's where I view our role right now, and why I'm saying. We want to continue to oppose this is based on what we know now. This is not the best value for the ratepayer. Staying where we are is.
Can I ask if I may?
Sure.
A couple of points, because you're talking about where we go. First, before I forget, Nick, I do have a question as to whether or not the board had authority over capital expenditures. But if we could hold that response for a moment. To be clear, Jake, we have never presented, we don't have a cost estimate for the building. And when we say combined, they're not, I don't know what your conversations have been with other managers or light board members. We're talking about a single building with separate facilities. So it's not combined, I don't know what the other scenarios were for these other communities. The light plant would have its own space and DPW would have its own space. So one, to be clear, because you keep saying these things and you have an audience here, I know, and Nick is here. Because we need to be clear on the facts. There's no cost estimate yet for the joint building. So there's no analysis that can be made, and one of the reasons that we are pursuing this, and you'll hear more about it next week, is that it opens it up to federal funding. You note that, and Mike and I have noted the capital projects that the town, their ratepayers will be faced with. Similarly, the town has multiple large capital projects also. And so we collectively need to make the best decision. One, as noted earlier, for the ratepayers and for the taxpayers. And so you guys are so far down a decision-making path with so little information. That's honestly the frustration. We are in the planning phase and trying to make the
But you would
best.
appreciate the fact that people disagree with you about whether or not it's a good policy or a good project, right?
Yeah,
I mean,
I'm
we're-
not taking a position, the other thing that keeps getting stated, I'm not taking a position on a project. We're
No,
taking
but
advantage
no.
of the funding to get through the planning phase that would have to happen for either building.
But pardon me, but you can appreciate the fact that people will have disagreements with you about whether it's a good idea or not, right?
That's fine, but then let's.
Well, I mean, I think that's what we're advocating is that we're saying that that's our position regarding that project or that, I mean, I don't see why we're doing something wrong by
Who said
expressing
wrong?
that we are disagreeing with that policy or that project. I mean, that's what we're doing for the last few months and for, you know, whether we could cooperation doesn't mean that we just rubber stamp things or we just agree to things. We have a job to look at it and to analyze and to think whether or not this is a good project or not.
Yeah, with all due respect, absolutely, I don't disagree with that at all. But decisions and statements are being made with information that hasn't been presented because it doesn't exist yet. If you know, Jake, you stated that staying at the building would be less expensive. You don't know, none of us in this room know that,
I said, based on what we know right now,
right?
what's been presented to us, which is
Which is what? All we is,
The-
the needs
the-
assessment has said that the existing building is not large enough.
right, and from the previous operations manager, that's not what we heard. And I am happy if you would, if you're employed, but if you would ask Mike what his thoughts are on a proposal for a garage in place. Where we are now, happy to hear his opinion. I think we know what his opinion is, and what Stephanie, I think it was your point, Jenna. Not confusing you, but we've unpacked a lot of topics here in one conversation. So that's on the topic of what I've asked other lifeguard managers, operations managers, and commissioners about a joint facility. All I said was shared roof. I understand. You did on the record say that there'd be different utilities. And I think a meeting, or maybe not a meeting room, maybe it was a break room was like one of the common areas, but there'd be separate garages, utilities and all of that. I understood that and I framed my question in that and explained essentially under a shared roof, same address. We'd have two different departments working out of that building. Here's what I know, and I gave them the ones that were willing to look, I gave them the drawings that we saw. Well, actually, I think a rendering from April 2025. That's what I shared, and the feedback I got was overwhelmingly. Don't do that. You struggle to separate the color of money between taxpayer and ratepayer money if you're under a shared roof. That's mostly what I heard on the commissioner side, and the manager side and operations folks told me, based on what you're showing me, you know, how big are your trucks, which I didn't know the answer to. And I said, you should really look at that. You might have a trouble turning them around or what have you. And I don't want to get into those specifics. I'm not an engineer and I don't know the size of our trucks and how much turning radius they need, but I wanted to respond on that.
And I think we have an initial estimate of a 4-bay garage. And it's in the $1 million range, plus or minus a couple $100,000. This is either a metal building or a block building. And I think it's safe to assume that facility that the plans that I've seen would be in the $40 to $50 million range. Now, you're correct, there has been no solid number on that. But at the same time, it's going to be in that category, maybe more if site work has to be done. If we have to put pilings in, it could be even more extensive. So, just because we don't have a specific number doesn't preclude us from having this discussion of what is best for the ratepayer and what's best for the town. So I feel that it's incumbent upon us to have this discussion now. We are in phase 4 of this grant, which is pretty far down the road. The grant's been going for 3+ years. And if we don't make a statement such as the resolution that we are not in favor of this, we are against it, that it would appear that how do we get this far if we are against this? That's one of the fundamental things I don't understand, that why is Hull Light still part of the joint facility when the board unanimously felt unanimously that we should not participate in this.
And this goes back to, so one, I'm not debating the project with the board. This goes back to the earlier statement that the town, those are town properties. And at some point, it's not unique to just the garage. We need to make a decision about how are we gonna proceed on all these capital projects? And so if somebody came and said, we have an opportunity for public funding that not being taxed nor ratepayer funds to pursue one, again, the planning portion, what are the needs at the light plant? What are the needs at the DPW facility? And what will the needs be? Why wouldn't we pursue that? In furtherance of that, if we know that there's likely significant federal construction money for a project, yes, as a town manager, I'd say we have do we just forego this joint facility right now because on the sheer basis that the light board doesn't want one building, and then later we'll have to come back and deal with the light plant building on its own, which makes it an entirely different project. And that's why we're going down this path of determining, getting the facts before a determination is made one way or the other. And there's nothing right now, even though we're at phase 4, it might sound like, oh, we're at phase 4, that says we can't separate these locations. But we're still in that planning and fact gathering phase. And so the only frustration from my perspective is the narrative that it's a fait accompli, which it's not.
I have another question for.
I would say that part of tonight's discussion is looking at a garage for our facility. And I feel that is being stalled by the fact that we are potentially in the future going to go into a joint facility, and we need a building that can take New England weather, snow, temperatures, and that's as far as the assessment I know, the environment panels, and even the current manager, operations manager. We don't need clerical space, we don't need office space, we don't need customer service space. It seems to be adequate, it seems to be working. And a transition to another facility with an elevator that we don't need, with
Well, even that, the current facility is not ADA compliant. I mean, that's
Right.
an issue. So
exactly.
these are all the decisions that are being, or the considerations that are being taken into account. And I just want to say, Tom, I know garages later on the agenda. It absolutely is not being stalled for any reason. We're doing our due diligence in what our garage options are. So I just want to be very clear on that. One thing has absolutely nothing to do with the other, and we're very aware of the timelines. In terms of need and the timelines in terms of the garages that are being explored, and being able to have those in place before the winter.
Yeah, and I am not going after you, Jen. I am simply asking a question, and I want to make it very clear. Part of my anxiety over this proposed or grant process is that the first one I saw, and I don't know this, but I think Phil might have been our light plant manager at the time. But what I remember seeing was a proposal that took a little slice of land from the HRA and added a parking lot, a paved parking lot. I don't know if you've seen this, Mike, but what Panos showed me way back when, I think was an output of phase one was, and I wish I saved the drawing. I just visually saw it with my eyes. But what I remembered was towards the HRA lane, you had a new or expanded parking lot, not the dirt lot that's there now, paved. There was a ramp, and then there was a garage, but it wasn't quite what we've talked about here. And we shifted the use of the existing buildings there where some of it's now storage and there's no trucks in there. Long story short, phase one looked like, I don't know if we could get HRA property, but okay, it was that. And then somewhere between phase one and phase three, I don't know when, it seems like the concept being pursued went from, and I don't know if phase one even touched the DPW. I have no idea. I just saw the part that touched the light plant, and it was there, and it wasn't adding any other department to the light plant. But somewhere between then and now, it's shifted to a combined facility at West Corner. And that is what is giving me anxiety, and I think maybe the rest of the board's feeling the same anxiety. Is it's like a decision was made and a path was picked, and that's what's been developed since that pivot. That's what I think you're seeing.
Jake, planning projects, dual projects like this, that's what happens in the planning phase. Plans evolve and change for a variety of reasons. What is the anxiety that's being created? I don't know how many times we can all say it's there's still room for change.
Sure, the anxiety is coming from the most preliminary phase of this whole process of that allowed us to get some concepts paid for design, engineering, whatever it may be. Drawings we saw were Panos was on board with that, staying in place and developing what we had. And from some point there, it pivoted to we're moving away from Edgewater entirely into a joint facility. And we've heard the range that I remember hearing last year was 30 to 52 million. And that's a whole year old, so who knows what it is now. But that sounds like a big number. And I've heard that we'd have 30 to 33% of the square footage. So if that was roughly what Hull Light would have, and we were there, I'm assuming Hull Light, ratepayers somehow would have to pay for a third of that building.
That is an assumption.
I know, that's what I just said, it was an assumption.
Right.
I'm operating on what we have, and we're saying we don't want that.
Operating only on what you have, because I keep saying, we don't know, we don't have a cost estimate, so we don't know what the cost is. We don't know what the split would be, and we know that there's an opportunity for federal funding to support the construction at a minimum. So we don't know what those numbers are.
Does that federal funding require it being a joint facility or no?
No,
That's great to know.
Okay,
and can we go back to the capital spending question though?
Can you hear us, Nick?
And I'm sorry, what was the question?
So I had, in the beginning, when I was trying to answer a lot of different topics at once, I made a statement that my understanding is that essentially the town manager, who also is the light plant manager for now, the way it is, not talking about any hypothetical down the road, under our current charter that we have to all work within. The light plant manager basically has operational control over the finances as far as day-to-day regular operations. But when it comes to anything, you call it below the line, so capital spending, if you wanted to spend a bunch of money from your depreciation fund, that sort of thing, that's policy making. Basically, I look at them maybe a little different than you do, Nick. I look at it as policy making. If it's a policy making decision, that has to go to the board and it has to be at least a 3-2 vote to become the policy and go pursue that. That's my understanding. And then operational spending, we don't touch that. That's totally the light plant / town manager under our current.
But capital is not below the line.
I'm not so sure you can draw such a bright line, Jake, okay? Right? And I think you gotta work together. The light plant board has the obligation to oversee, if you will, the assets. All right, that is essentially what you do. The 93 Act says the operation of those assets goes to the town manager as the manager of the light plant, and all that kind of, things we talked about. So let's talk about depreciation. Let's talk about the depreciation fund, right? The determination of depreciation has nothing to do with the diminution of value. It's an internal cash generation approach. And the DPU has regulations and laws that you can have 0 depreciation or 5% depreciation. And it's on gross plant, not net plant. All right. It has nothing to do.
Say that one more time. It's on gross what?
It can be, pardon me?
We missed gross and then whatever you said after that. It's on gross what?
It's on gross plants, not net plant.
Oh,
In other words,
you.
in a generally accepted accounting principles, you would deduct the depreciation from the original cost of the asset, and that would be the net plant, right?
Yep.
Okay, that doesn't exist in your accounting, and under the DPU, the depreciation fund is designed to accumulate cap money for capital expenditures, etc. And it says it right in the statute. It says it in 164. So how does that money get set? That should be on the budget of the manager, right? The manager can make a determination that we're going to go with 0% depreciation to be charged to the ratepayers. All right. Now, if the manager should be talking to the board about that, saying, if we do that, we're not going to accumulate any funds for any capital expenditures. On the other hand, the manager can say, I want to go up to 5% because 6 years from now, we're going to have to replace, I don't know, a whole bunch of poles or something. And we don't want to really borrow for it. We want to use internal generated funds to pay for it. That 5% is going to be charged to the ratepayers. That's operating money, right? So that's where the interaction comes in. That's why I'm trying to tell you it's not this sort of bright line that you're talking about. It's not designed that way. Okay, so that gets you to a fund that can be utilized for capital additions. But the money going into that fund comes from operations, right? And that is set through a budget. And that budget would have either 0, 2, 3, 4, or 5% of depreciation. And you can't simply change it. You got to go to the DPU to get approval. So if you were at 3%, you got to get the approval of the DPU to go to 4% or go to 2%. You just simply can't do it. That's the regulation. That's the law. So it's not really that bright. You got to work together on this stuff. All right. It's very, very important. All right. Now you have the money. assuming you work together and everyone's agreed that it's going to be 3%. And that money comes in and it gets put into the depreciation fund. And under the law, there's only certain things you can use the depreciation fund for. One of them is for capital additions. Okay, now you have a choice. Well, let's say the manager or the operations manager, however you work it, says, you know something, we got to replace half the poles because they're rotting, because you're by the water or something like, or a substation or something to that effect. I don't know. That's going to cost a lot of money. We have a choice. We can borrow for it or we can use internal generation of funds to pay for it or a combination of the two. That decision, I think, is the light board's decision in conjunction with the manager. We're going to, we're going to use these funds because we are in charge. We oversee, not in charge. We oversee the assets. And that's where I think you guys have to work together in that manner. And that's what's done in virtually every single light plant. Not virtually, all of them. It's not that bright, Jake. It's not this bright line. In all sincerity, please don't take this. I think you're looking for bright lines to talk about control. Get off it. Get away from control and get together and work together. All right. What difference does it make that the town is seeking grants for a building? It really doesn't make any difference. Not to you. What makes a difference to you is whether the design of that building to be, if it's shared, is something that meets the obligations and requirements of the light plant. That's what's important, not whether the town's getting grants or they did it 20 years ago or whatever. That's irrelevant. What's relevant is the design as to whether, in fact, it accommodates the needs of the light plant. And those needs are defined in part by the operations manager going to the board, and that's the board's responsibility, just as it is for the board then exactly the same thing, going to the select board and saying, our interest and our professional judgment is, this isn't going to work for us for the following reasons. Getting grants and so on is not relevant. It's the scope and design that's relevant.
That answers your question.
Yes, thank you.
Thanks, Frank.
I see that one over well. I'm joking. You got to have a sense of humor, Jake.
Are we on the next item?
Next item 6. 7, we did that, we did 7. We got 6. Okay. Item 7 is, let me just introduce it, Item 40, home rule petition. Discussion and possible vote authorizing the clerks in consultation with the chair, the draft light board testimony on Article 40 home rule petition. The board composition has changed since we took the since we took a vote on Article 40. We've been told by Representative Spino that the support for Article 40 was 3-2. Now, with a new commissioner on board, I think it would be appropriate that we address that issue that Representative Mosquito brought up, and being force our vote even stronger, if possible. I don't know how it's gonna go. But I would like to take another vote, before we get to any discussion on, coming up with a draft testimony, on Article 40. So at this time, with our new commissioner on board, I would like to pose to the board another vote on Article 40. And, on the board.
Do you want to make a motion?
I make a motion for pending discussion,
What's the motion?
motion that whether or not we're going to authorize the clerk in consultation with the chair to prepare a draft with like board testimony.
No. I think the chair wanted to make a motion before that, just about whether or not to endorse it.
Oh, I'm sorry.
The conversations we had with, that she inferred that, she, I think, would like the 5-0 vote.
Well, what I would then do is I would make a motion pending discussion on whether or not the board approves Article 40,
I second that.
pending discussion.
Should we? Emphasize?
Well, I'm gonna open it up to discussion so that the people can talk about
Okay,
it.
So Article 40. Oh, maybe she's not here. I thought Leslie, oh, she's here. Okay. Article 40 was a citizen's petition and Leslie Taylor is the petitioner. She's here. I think it would be incumbent upon the board to just hear from the petitioner for 1 or 2 minutes before we discuss it as a board.
okay, but, and I appreciate that, but at the same time, I believe it's going from a citizen's petition to a townwide, petition. Since we had 75% vote on that, but I'm not sure, but sure. And I'll give deference to the, petitioner. But I feel that it may have gone out of your hands now.
I'm sure it's out of my hands. I just want to point out that in 1993, everything got turned around all the way through the legislature in a couple of months. And I'd like to point out something else that when, and I said this in my presentation at town meeting, that when something goes into study, only 3 in 1,000 come out. They're otherwise, the legislature, this is a wastebasket for the legislature. That's all I wanted to say those 2 things, because the town, I think the vote was very clear. I don't think I need to revisit that other stuff, just that somehow this charter change and everything happened in a couple of months in 1993. Bill tried in 2011 and Jake tried in 2023, and it keeps coming back. Last year, they put it in the legislative wastebasket. 3 in 1,000 come back out of the legislative wastebasket. That's what I just wanted to say.
But since I believe it's going from a citizen's petition to a town endorsed
Right,
motion.
it's on its way to the state.
So-
legislature.
And I'd like to reaffirm the vote with our new commissioner.
I just have a quick question. I'm familiar with the title, with the Article 37 and then Article 40, and I've been hearing all the pros of it. Are there any cons?
I think it's a con we know about, which is that there's a change and that we all collectively would have to adapt to that change. And change management is a whole science in and of its own field. So there is a change. But I, outside of that, don't know what the cons are
The other question, what was the vote? What was the vote of that?
for which one, 37 or 40?
For 40.
I'll have to look through my pictures. It was 74.2% affirmative, but I'll get you the numbers in a second.
So 74%. agreed with the 40.
Right.
That's all I need, Jake.
I wanna put it in the record now. Make sure we don't miss out.
Mark, I think, I'm not sure this is a con.
The vote was 236 yes, 82 no, total of 318 for 40.
I don't think this is a con, I'd say this is a transition. Currently, we do not pay for a light plant manager. But we do have a operations manager and assistant operation manager. I believe what will happen is that, when 40 becomes enacted, we would hire a light plant manager. Which would, I would say, be marginally more cost than the operations manager. So there'll be a slight increase if we, and I would also say that we would more likely eliminate the assistant operation manager's position. So the managerial staff would probably be reduced by one, because the current manager would no longer be manager. And then we would have, an operations manager. And then we would have a light plant manager. And we wouldn't have assistant manager, so there might be a slight increase in payroll. We have the second largest budget in town, we have $12.5 million. I don't think you could even see that in our total budget. I think that might be transition, I'm not saying that's a con, I think that might be. That was an argument that had come up by the advisory board, and other members that said that if we can keep the current structure of having three managerial positions, or light plant manager, assistant manager, operations manager, and operations manager, that they would just be reshuffled. So it'd be slight,
So that basically is gonna be zero difference.
essentially.
Well,
So
everybody knows my position. I spoke at it both in
Right.
meetings. I think that we should vote unanimously for this motion. Because I think it's been demonstrated, it's the will of the people. And I think that we should vote for unanimously.
So I was opposed to Article 37 and I'm still opposed to Article 40. My position has always been that I was more concerned about the way the citizens petition began because of concerns of a previous town manager, like planning manager, and there were concerns. Right, there were concerns, I agree with Dan at one point in time, but then nothing happened with that, nothing materialized with that. So fast forward.
other than the fact that Dan proposed that action at town meeting back in
Yeah.
2011.
2011.
And then,
I mean, I don't want to interrupt you.
Okay.
and then went to committee, but he attempted to change that. He didn't do it every year.
No,
He
no.
did it back then, but this one.
So my position was the fact that the issue was with the previous town manager. My position is, I believe the current town manager deserves the opportunity to do the job that they were hired to do. And I don't think we've allowed that to happen. So that's my position.
I call for a vote.
Okay.
Where are we going?
You want me to go first?
Yeah.
You know, I think we should do these votes alphabetically, but I, Dan Chicarelli.
Hi, Jake Valancourt.
I'm Tom Burns.
I'm Marco.
Name, Stephanie.
Mr. Chair, before you move on, well, just one kind of point of information, you actually don't need to do roll call unless you're all virtual or during meetings, so you could just vote collectively, if that helps. But because you do have staff here, can I just ask clarification, is it the presumption that, including the assistant operations manager, that it would be eliminated in fairness, presumption that everyone would slide, those positions would sort of shift?
I think that's in the realm of presumption, yes, but I don't want to. I would think, we'll say we'll say the plant manager. I think everyone would have to, that would be an advertised position. I don't know, I can't speak for Mike, but I would imagine he would apply for that. He might, know the operation better, he might be more familiar with the facility than almost anyone else. That will be very highly valued. Which would, if we chose him, then that position will be vacant. If we didn't, then we would choose someone else from the field. That position then would be open, and then we would have the opportunity to advertise the operations manager's position.
So typically, you would hire the general manager, then the general manager would do all the
Oh,
hiring.
excuse me. Correct.
Yeah.
We would not, we only have one.
Yeah.
We would advise the,
I think you answered it.
yeah.
Yeah.
Whatever.
I'll say as a commissioner, I have no intent of eliminating Dan or Mike. That's not what I'm trying to do, and I think that Nick, this might become a question for you, so I just want to make sure you can hear. But my understanding of 164 is that if we were under the standard model after 40 were implemented by the legislature, hypothetically, all this board does is hires a light plant manager. That light plant manager then would do the reorg how he or she saw fit. That's my understanding of it, which means we really only have, like we said, one choice to make, or not choice, sorry, a hire. And then that hire has to figure out the whole org chart, whatever he or she deems as best. And that's it.
Yes. I would agree with you. That's. And if the flight plan manager decided that he needed an assistant. Operations manager, that would be his prerogative, it would be his justification. And whatever the case would be, that
Right.
it will be out of our hands.
Our role would be to hold the light plant manager accountable for performance and results, and so he or she has to either drive to that, or they drive away from it, and then we as a board would say, whoa, you didn't get us anywhere where we wanted to go, and then we have another decision to make, which is, do we replace that light plant manager? And you and I talked with John Jacques, I forget his last name right now, I'm sorry, but from Marblehead, and he had, they had to go through getting a new light plant manager recently, and he had a lot of really helpful information to share with Tom and I, and I hope that in the future meeting, if this goes to the legislature, we can disseminate that to the rest of the board, because I think it'll help us get ready for fulfilling that role.
Okay. And
Want Nick to confirm that?
Do you want to confirm?
yeah. Nick, say it correctly.
Did I get it right?
Sorry?
Oh. Can you hear us now?
Yeah, now I
Did
can.
did I get the understanding of 164 right? We hire a general manager figures it out from there.
It's right, it's under 164, the light board hires the general manager and has general super, what's the word? Operation, basically can provide general supervision to that manager. The manager hires, not the light board. So the manager would have, you know, staff, et cetera. It would also, the manager would also have to come to you with a budget to fund that staff and so on and so on. You know, that's just the way it is. I can tell you, as of last week, even in the city of Peabody, the Peabody Municipal Light Plant is again involved. The board asked the manager to engage a consulting firm because the board wanted to assure itself that the organization provided by the manager was the most efficient, you know, for the ratepayers, et cetera. And they did. He did. And that report was provided on May 28th to the light board, and it was, yeah, it's doing really well. You know, it's designed right and so on. So that's how it would evolve and how it would work. If that, you know, that's how you would work it through under 164. But it's the manager's call on hiring.
For Panos, we never had an assistant operations manager. But I believe Panos was hired because the operations manager wasn't in good health. And it became a succession plan. And I think that situation occurs again, you know, maybe the operations manager might, well, think a succession plan might be in need to,
I think you guys are going for it.
yeah, I know.
Yeah, I'd like to get back to
We
the
work for an assistant.
the agenda. I move that we authorize the clerk in consultation with the chair to prepare draft legislative light board testimony on Article 40, to invite anybody who would like to provide a minority report to be part of that. I open that up for discussion. I mean, I move that pending discussion.
Could you repeat that again?
I know you've asked that. I move that we authorize the clerk in consultation with the chair to prepare a draft light board testimony on Article 40 home rule petition and invite any other commissioner who wishes to provide a minority report to be part of that and to report back to the board at a later date.
So I'll open that for discussion. When Article 37 passed, it was,
Nobody seconded it, so.
I'll second it.
Oh,
I'm sorry. So when Article 37 passed, I spoke at town meeting. I felt strongly that if we were going to go forward with this, I would prefer a government study committee to discuss the issues. Because it was a knee-jerk reaction in 1993. There were problems, there were issues, and the town just said, you know, we're going to fix it by eliminating. You're not going to be able to do this anymore. So since 1993, we have set rates and we've advised on policy. Now, all of a sudden, we want to go back to the way it used to be. It didn't work the way it used to be. That's why we're here today. I would prefer more discussion, more input from ratepayers, from the select board, I think we need a group of people to sit down and say, look, we had this model, we got this model, that didn't work, this didn't work. I guess what I don't like is a one size fits all approach. It's either all or nothing. I'm not comfortable with all or nothing because it's not working. So I chose to speak at town meeting. That was where I felt I needed to give my position. Town meeting spoke and they voted and they passed Article 37. I chose to not submit testimony opposed to it, even though I didn't support it. That was my choice. I choose to do that at town meeting where I thought it was appropriate. Now we come back and Article 40 is proposed. I spoke again, Article 40 passed. I choose not to write a letter. That's my choice. I spoke at town meeting. That's where I think I should have made my position known, and I did. And it passed. So in my world, until such time as Article 40 becomes law, I will not do or say anything to prevent the process. There is a process now. I spoke when I felt it was appropriate. Now it goes through a process. When Article 40 becomes law, I will support it, but I won't publicly write a letter in opposition to it either. I did my job at town meeting. I let the residents of this town who were gonna decide what they wanted with their life plans, I let them know. They made a choice, I will support their choice. So I will not be sending a letter of opposition.
Well, I appreciate what you're saying, I think we still should leave it open in case any commissioner decides that they want to, how they want to do it. If the people choose not to file a opposition or even a minority report, that's up to them, but I think that people should have that option. You know, it's a deliberative body and people should have that.
Can I add to the discussion here? So I appreciate your position, Stephanie. And I also agree with Dan. You're an elected member of the board. There's 5 seats. And so Tom and I both met with State Rep Joe Moschino a few weeks ago, and a few days after that, we both met. And actually Patricia Lambert, who I think is here tonight, also met with Senator O'Connor, and both of them, I mean, they said different things, they had different perspectives, but they both gave us the same advice, which was pretty clear. Encourage the select board to send it to them as quickly as possible, and do your due diligence as a light board. We didn't submit any testimony as a light board last year for Article 37. Only individuals did. And Joan and Pat both, Pat O'Connor, state senator, they both said the board should submit testimony, letting the legislature or the committee, really, the legislature is not committee, but the committee that it gets assigned to is who you submit your testimony to, and they both encourage the board, the light board, to submit testimony so that that committee understands how this board that it directly affects feels about it. So that's why I asked Chair to put this on the agenda. I just wanted you to know that they're recommending that we do this.
I don't agree with them, but that's, you know, they can recommend it. It's a citizen's petition, it's not a light board petition. It's a citizen's petition. Citizens should send in testimony. And if a citizen happens to be on the light board, that's fine. I don't feel that it's a light board petition. So you're all citizens, you have every right to submit a letter in support of this citizen's petition. I'm just not comfortable with the light board doing it, because it's not a light board petition, it's a citizen's petition.
Right. Our representation in the legislature is explicitly telling us that the legislator, the committee that this gets assigned to will want to hear. They both have the same opinion, and I know that they're not aligned on all things politically, but they both have the same opinion that the legislature will want to hear this board's opinion on the matter. So I want us to submit our opinion. That's all I'm saying.
Like I said earlier, that it was introduced by a citizen, but it was adopted by the town meeting. So I believe it has become a town petition, a town position, and no longer a citizen's petition. It was introduced by citizen, wasn't introduced by us. But at this point in time, I feel that it's no longer a citizen petition. The citizen made the town aware of it and the town voted and then became a town petition. So. And we concur that, even the select board, I believe they just submitted it without any confirmation or, and I will encourage them that they should also add guidance that they feel necessary. So, I don't know whether it puts a stand up, whether we need if deputy's not going to.
Well, I mean, I think that it, well, then it should be mentioned in the testimony that it's a majority report. I mean, I just don't want.
I think we can honestly say it's a 4-1 vote.
Okay.
I think that'll,
Okay.
no, it's not unanimous.
I take it as an amended, I mean, a friendly amendment, but not to include a minority report. Nobody wants it, nobody wants it. I mean, we're not forced to.
The intent is to draft testimony for submission, and then after we have the June 10th meeting, when we reconvene in a meeting that's just a light work, for us to all comment on the draft, and then if we want changes, make the changes and then submit it. So the intent is not Tom and I as chair and clerk just go run. It's to work together to put a draft together, and then the rest of the light board in open session comments on what's in there. So the intent is to do this as a board, not. I just wanted to be clear on that.
Fair enough. I accept that as a friendly amendment.
I had seconded it earlier.
I don't see the need for it, so I'll vote.
No, I'm accepting that as a friendly amendment to the motion. So the motion is that to direct the chair and clerk to draft a testimony. So what?
Okay,
On this part. Okay.
that's a motion.
That's the amended motion.
Okay,
Amended motion.
well, I'll vote on that. Okay. First one is to go out of order.
That's good. What?
So it's my understanding that Jake and I will come up with a draft to be presented to the full board at our next. Not on the 10th, but at our next meeting,
Individual meeting.
and that we'll be able to push it forward. Is that,
That's the essence of my approach. Okay.
and I would vote for
Well, I call for a vote then.
that.
I'm just trying to get to the vote, that's all.
All right, I, Jake.
Hi, Tom.
And Mark,
I answered vote, so it's 4-1.
Super. Item 8 is the management updates.
Yeah, I can go first with the Edgewater Road garage status. On May 28th. We met with Ironmore Structures. They do temporary structures for garages. So take that with the work that we've done on the permanent garage and weigh those options. See how we move forward with those two different options.
When will you have?
He's hoping by the end of next week to have some possibilities, proposals, and hopefully some numbers on what the structures cost.
what is a temporary structure?
So temporary structure, you may have seen one at the DCR property that they currently use for a salt shed. So it's a concrete block foundation that can be set on gravel or asphalt. And then it's aluminum structure, and then they use it's almost like a shrink wrap for a boat. That's the type of material that covers the aluminum.
So the wall or block until you get to the roof, and the roof is basically some sort of like Tyvek or something like that.
Yeah.
How does that hold up in our weather here in town?
So I think he said, they can be built to withstand up to 150 mile an hour winds. So they have them, obviously DCR is in a similar location. He's built structures in Situate, Marshfield. And I believe Rockland, so there's a couple of structures that we're gonna. Maybe take field trips to and take a look at.
So you'll have a cost on that structure. You also have a cost on a metal building.
So to get a cost on the permanent structure, we're gonna have to essentially go to design, conceptual design. To get construction drawings, then get an estimate off those construction drawings.
So
I think it'll be easier to get a price on the temporary structure.
So we're looking at a comparison. So could you work on a permanent structure? How would that?
Yeah,
Sure.
so Chair. I'm gonna just read what we voted for on, what was this, November 20th, 2025. A motion was made to propose the capital project to fund a garage at 15 Edgewater Road to store fleet vehicles designed to allow for solar orientation and complement the historic nature of the existing building. Vote was unanimous in favor, and I don't think that the temporary building that you're talking about, Mike, frankly, doesn't align with what we voted for in November, so I think that I appreciate it, I understand it, but the last part is very specific, complement the historic nature of the existing building. I don't know what this thing looks like, but obviously we're just talking about it. I don't think that a temporary structure with canvas does that.
You certainly won't have a permanent structure by the winter.
That was 7 months ago.
And then given the earlier discussion about understanding what the options are going forward, that I would not say that that's the most responsible action to take. Given the earlier discussion about not needing to design a building or potential relocation, not having those answers right now, that it wouldn't be the most fiscally responsible option to design a permanent building at the current location at the expense, which would certainly be a few $1 million. So if the goal here is to house a vehicle that we're anticipating in the fall and to work together in assessing the best options moving forward in terms of structure and building, that the options Mike has pursued are the recommended options.
It's the recommended options from you, I understand that, but what I'm trying to convey through the chair is we didn't vote for what you're doing at all. We voted for something that's very clear, and it sounds like no work has been done to bring us an option that is aligned with the vote. So in an effort to work together, how can we short circuit this and get to what we asked for in November? What would it take for us to get something that you're talking about, Mike, where we could bid it out? I don't know the process. I'm not in the construction industry, so I can't plug in and say, oh, here's how to do it. I don't know.
We would have to hire architects, engineers to design, to come up with plans, specifications for a permanent building. That comes at a significant cost as well.
If we went with a metal building, which would be very similar to manufacture of a temporary structure. A design could come forward within weeks.
No, because we have to procure it for.
It's also some master plan which comes with.
Couldn't, I don't know why we couldn't get a cost estimate on
Because there's a process involved with it, Tom. We would have to we would have to procure for those services, putting that RFQ together, putting it out, posting it, getting responses in, evaluating those responses, selecting a design engineer, architectural firm that then would come in and do the work to do the assessment to find out where, what is the facility? Is it a one bay garage? Is it a 4-bay garage? Is it in the existing garage? Does that need to come down? That was all going to take a significant cost and a significant amount of time. And while we're in the planning phases of building, whether it's joint or not, this is the option given the priority to have this vehicle housed for this winter.
I see. A delay of not doing what we requested or voted on. And we're in a position now that they're giving us only one potential consequence. If we could cross out a metal building, I mean, we would, at the same point in time, we would have to do the same bidding process with a temporary building. That I see just due to the delay, we're in a position that we're being forced to accept a temporary structure. I also see the fact that this joint facility is impacting our decision, which unfortunately I don't think it should be. I think our needs are needed, and if we started to look at this back in this was November
18th, 2025.
If we proceeded at that point in time, which I think we did get some initial engineering done on it, and that came to a stop. And then months had passed, and then which valuable months have passed, that now we're into a situation where we have to accept a temporary structure, which in itself could be $400,000 for something that might only be used for a season or two. Where if we went forward on a permanent structure, 4-bay garage, I think we've always thought a 4-bay garage. With a specific orientation, whether it was stucco or metal. I'm not saying fast track, but I'm saying that we put as much effort into it as possible and see where we go, see how far. These buildings are relatively straightforward. There's no plumbing, there's no AC. It's a pad and straightforward building, whether it has windows or not. I'm not talking a very complicated building. I think the operations manager should go forward with a permanent structure. And if he wants to I don't know, I'm not happy with the temporary structure. I don't see that serves the ratepayers better. If we ultimately need to have to abandon structure that only is used for a season, and that just adds to the ultimate cost. And if we had immense work back last year, we will be far along. We probably would have had bid it and probably would have been under construction, but due to delays, which I think were. I don't know. What I hear you saying, Jen, is that, we should wait till the CZM grant is completely vetted and then make a determination on this, and in the interim, build a temporary structure.
Yes. That property is in a flood zone and this grant and the work that is happening is guiding our future decisions and investments.
The garage will be at 15 feet, it's well out of the flood zone. That won't be in the flood zone. But we can discuss, you know, the resiliency of both sites. And I think it's pretty obvious West Corner is far less resilient than 15 Edgewater.
I don't think that's the findings right now, but I hear you.
Okay,
Is it possible to, these buildings big enough? How this is gonna put in place temporarily in town?
So we have looked into garage space and there is garage space available. That could fit the truck.
Did they work through the financials on that, why this other plan is going forward, if you lease the first season?
We just did initial talks with what was available, we didn't get the price.
And did you find something in town?
We did, yeah.
I think that's a much better idea. For than putting money into the temporary. Garage, I don't know if they call it garage, whatever the temporary structure building is called, old barn garage. I'd much rather see us do that and develop what we voted for last November instead.
Well, that seems to eliminate the issue of conflict between that and the structure down in the proposed.
West Corner.
Yeah, West Corner, and so at least give some breathing space. To determine whether or not it's gonna be part of that. Right?
Yeah.
And there are some cons, obviously, it's off-site from where we are and issues with security, with access, so a lot of those things. Flushed out.
Are those something that, are those issues? Neither.
Possible.
We have a problem.
Well, then I'll ask them, we put that on the agenda for the next meeting.
I think we should make a decision tonight. We've already waited 6 months on this.
Well,
But I think we should need to discuss it a little further.
yeah, I think so too, and I think that
Are there any? Any option? If you know. You do anything we have right now. To move one of our existing value drugs.
So we've looked at shuffling trucks around. We have to raise the roof on one of the garages to be able to have it fit. We'll also look into that. But again, do we wanna put all this money in? If we. End up building permanent structure, temporary structure, or a joint facility, so.
well, I would move that we ask the like plant manager to provide some of that information about storing the vehicle off site for the next meeting.
I'll second the motion.
We move forward on a permanent design.
Well, I mean, I think that this,
Still stands.
is that, oh yeah,
Our vote still stands from November, it hasn't changed.
I think so, but I think that we may want to have, I mean, there might be other options that might be more appropriate, given the fact that it's June and we're not gonna get a permanent structure.
Oh, yeah, no,
By next year, by the fall, so I mean, I think that if there is an option. As Mark had said, to store off-site. I think that we should look into that, we should request some type of information on that.
I agree.
And then discuss that, and then maybe it's the better of the options. I mean, I agree that we voted that way, but I mean, that doesn't mean that we can't have a variation of the theme. So anyway, that's my motion.
But couldn't we concurrently come up with a permanent design?
Well, that certainly can be, I would suggest that certainly can be discussed in June, for the next meeting. But it doesn't make any, I don't think that it makes much sense to talk about it if there is another option that's available. That we could think about.
Well, that option's temporary, right?
Of course, yeah.
I view our voters had authorized Jen and or Mike to. I mean, I think if I read this. It authorized them to build it. We didn't ask them to come back. Then, I mean, it implies, go forth and build the darn thing. The historic nature of the existing building. And, maybe that implies it connects to the existing building. I don't know exactly, but at least it doesn't look like light and fits in with the neighborhood essentially. That I think aesthetically is what we were as a board unanimous on. But my point is, if they haven't yet, I think that vote already authorized them to go out and get an architect or an engineer or both to give us a price on that building. And in the meantime, it sounds like we may have a very real solution before the winter for temporary storage that we rent. So both can be pursued in parallel simultaneously and discussed to the next meeting.
Yeah, I'm not saying to exclude any of the options. I'm
I
saying,
thought you were.
oh, no, I'm saying that we were to ask the life grant manager if the operation manager could give us that information about storing it off-site. Just to
Sure.
allow,
But I think it's time that we start working on a permanent structure.
well, that can be discussed during that same.
So now we lose the whole month again, so now we lose. I'm just assuming that an arrangement can be made,
I'm assuming that too.
so. If the arrangement's made,
I mean, look, the thing is that there's a permanent structure, there's a temporary structure and off-site, right? This is the first I sort of heard about off-site. And I wanted to get some more information about that. If possible, that instead of building a temporary structure, that could be done while we hash out the permanent structure. Also, that we're getting information about the the dual use structure. And that's gonna, I mean, I'm not saying that excludes the permanent structure, it's just, I just think that we should get all this information right away, as soon as possible.
well, so we've delayed 7 months already.
I know, but our next meeting is in 2 weeks. It's on the 18th. We're gonna keep that meeting.
Is it the 18th?
Yeah.
Oh. I thought it was the 20 something, sorry.
Does that give you time?
The 20th?
No,
Both
the 18th.
Mike and I are away that week.
Okay.
Yeah, I thought our meeting was like the 24th or something. Hold up.
I think it's and it's
Sorry, the 25th. I thought it was the 25th, that Thursday.
Right.
I'm going to be away the 25th.
Okay.
We could do the week after.
That's now we're into July.
I mean, I think that
I
we
do
should,
it today.
I think that's July 2nd.
I don't want to do July.
Yeah, the second and the third, I have plans.
Right.
So,
Which is the July meeting,
And normally in July, we would meet on the 16th.
16.
so that's 7 weeks.
I think that the board already authorized, frankly, the construction of a permanent garage. So it sounds like possibly the board is unanimous in that we don't want a temporary structure. We don't want to put ratepayer dollars into a temporary anything.
I think that's, without voting on it, I think that's the consensus.
Yeah, and I think that's what we're hearing. So maybe we take a vote that advises the life plant manager and ops manager that we're opposed to a temporary structure. And that we would like it, whenever our next meeting is, we should hash that out too. But for the next meeting, single meeting, not the joint one. That will have more information on the leasing or renting of offsite garage. That's the temporary solution to this truck that's coming. And we can discuss further, right? We would expect them to have basically progress made with the architects, engineers, however that works, so we actually get a price on the permanent building, but we already voted for the permanent building, so. To make them, I guess that's probably two motions based, if I follow Nick's advice. First motion is that the board is opposed to an erection of a temporary garage. Just take that, that's my motion.
I'll second.
So the board is opposed to the erection of a temporary garage.
Burns, yes.
Oh, yes.
Jake, yes?
Chip Early is.
So before we go too much further, I'm just looking on the April 28th meeting.
It's a
Under the
motion.
garage project update. It said. Commissioner Cannon requested an update on the 4-bay garage at 50 Edgewater Road. Be added to the next regular meeting agenda, including the status of bids in design progress.
Yeah,
That's what we have.
that's what we had asked for.
So we're saying that a 4-bay garage is a permanent structure. Not a temporary, not a
It's
stable
never,
building, not
it's
a.
never, it's a mixed, no.
You,
So the vote's still open.
No, I think we
No.
voted, it passed
Oh.
unanimously.
I don't think
Stephanie,
did you vote
I
for
thought
it?
you voted.
Oh, you did, oh, I'm sorry. I was just.
Yeah, do you want me to reread them up? And I think the second motion, if the board wants me to make it, would be, I move that the board advises the life plant manager to, progress the design and cost estimate of the build the permanent garage that the board voted on in November 2025.
And also information, storing it offsite.
Apparently, I take your very friendly amendment.
Friendly amendment, yeah, okay, yeah, that's a.
Sure.
It's actually his amendment, but that's, I'm just speaking for him because he's.
That's what I think.
I second it.
Burns, favor.
Jake, aye.
Oh,
Chip Early, aye. What'd you say? Okay. Alright. That's with the battery storage project.
Yes, well, as you know, as you all know, we've been obviously looking to the battery storage project. MWIC has pre-bid projects, and that is the light ship project that we saw in Wakefield. So that's one of the options. We're also getting proposals from 2 other battery developers. And then MWIC will do the analysis on those 3 and also take into account the option to purchase the battery. That's all ongoing.
Like, what do you think will be the date we have, like, will it be a presentation that they're gonna make, or you'll just have a deck for us?
I'm pretty sure MWIC would make that presentation on the analysis.
Okay.
Yeah.
What do you think that'll be?
We met with the second developer, was it this week? This week, they obviously have to do some legwork get a proposal back to us. And then the third developer thinks he can have a proposal to us probably within 2 weeks. So then I'll be to MWare. I'm sure how long their house is gonna take.
Probably this summer.
Yes. Questions on that? So staffing updates. Janice Ford, who was our finance manager for over 20 years, has retired. She's back part-time to help with the transition with our new finance manager, who we just hired, Oksana Holmes. She comes with a very strong background in accounting. She was previously the assistant town accountant in Hingham, and then most recently the accounting manager in the town of town. So she's been here 2 weeks, and just been working out great. Excited. Janice will be here part-time until Oksana is fully trained and comfortable with the job duties. And I want to congratulate Mark on the election, the win. All the other board members have had the opportunity to kind of do like an orientation. And I'm happy to, spend a half day with you, show us our operations, show you our operations, drive the circuit that feeds us through Hingham, and see our infrastructure, building, staff. But I think it's helpful to understand the business, because obviously you be on that board making decisions, and it helps to get context on how it works.
I appreciate all of it. Okay, as much as I can get, I appreciate it.
Members need a refresher, or how you go accommodate.
On sort of that note, I think that we should do something to commemorate Pat Cannon's tenure. Maybe we should talk about it. I mean, I'll be happy to talk to the chair about some of my thoughts and bring it in front of the board. But I think that we would be really amiss not to thank Pat in a more
And recognize the
appropriate,
20 or 30 years of service.
35 years of
Right.
and the accomplishments, and just to let him know that we appreciate it, that the board appreciates all his work and stuff. So I'll talk to you about some thoughts I have before keeping back to the board.
And make a decision and.
Yeah.
Expeditiously
Possible, yeah.
put in that trip to wherever he wants to go.
Yeah, right.
Usually Disney, what we've done before.
What's that?
Disney is what we've done before, and then
Yeah, you're right.
all I have for financial updates, unless Jen has anything else.
I think that,
Great, item 9. And I want to apologize for my coughing outburst here. Hopefully I can finish this meeting.
I just was wondering, should Attorney Scoble still be with us?
Yes.
Well, I just want to talk about one last item,
Okay.
which is our newsletter.
Okay.
We put out a draft of a newsletter, and then it was being reviewed by life plant manager, and then we had elections, town meeting, and it never got any further than just a couple of edits. I think it's very important that we have a newsletter for our ratepayers, and that they don't have to depend upon third parties or the old times exclusively to find out what we do, so they can understand that. There's some items in there that are no longer germane, but I would like to see that we can get another newsletter at our next, I'll present it at the next meeting, try to get this vetted beforehand, so we can just vote on it, hopefully at our next meeting. I would have to ask the light plant manager if we could use, Light Plant staff to help put this together.
So we actually have some recommendations for the newsletter, in terms of frequency. I think quarterly would be sufficient or recommended.
I agree.
And if the board has thoughts for content in terms of what you'd like to see in the newsletter, to let us know, we can draft, or if you want to send through staff a draft of something we can look at and edit, and then to issue the newsletter on the Light Plants website as well as the town's website.
Is it possible that we could follow the path that the CERC commission uses and have a printed copy?
Right now, your bills are primarily electronic. I don't know what the breakout is between electronic digital invoicing and people still get paper.
Could we do?
So you have an option of doing a stuffer, which is an additional sheet. And then anyone that gets an e-bill will just get a PDF of the newsletter. We've done that before. They was sent out. Newsletters for like the senior center. Some other. Services that we need to go.
I would hopefully feel that we could communicate with our ratepayers the same way that the CERC commission does, and if we just do 3,000. And I realize these aren't free because this will be colored, double-sided. But I think the ratepayers deserve to know what we do. Some of the issues that we had before, we could include in the spray article, we could include the.
Why don't we come up with the sketches, recommended schedules, and we could send it out to the board and deadlines that we would need content by, or ideas for the newsletter.
Okay.
I mean, we're not suggesting that people don't get the newsletter. I'm suggesting that even a broader audience get the news, or access to the newsletter by having it on the websites.
So we can send out a newsletter to those people that have seen. Making copies of the bill.
Yeah.
That we're agreeing to. And then. Because. Quarterly. I don't know, but something like that, $2.
Yeah, we can get the pricing.
Yeah.
It depends on color, simplex, duplex.
Yeah, I'm sure, I mean, I'm concerned about the price, but I think the ratepayers deserve. A paper copy for those people that receive one, and it's easy enough posted. These two websites. Okay, we'll get that moving.
Do we have old business or anything, or?
There's no old business or no business on the dollars.
The only thing I was gonna ask you is that I have about 20 years of agendas and different stuff given by MWIC. Do you have a archive or anything like that? Do you,
Yeah,
would you like it?
absolutely.
Okay,
Yeah.
I'll donate it to the,
Great.
but, okay. I'll try to redact my comments on the agenda.
Thank you.
Sure, we got item number 10, agency correspondence updates. I believe this was on resolution.
Yeah, this is all related to the April 28th resolution, which authorized me as the clerk to send the transmittals to these state agencies, as well as the town manager, as well as the select board, which I did. I actually sent them all out same night of the meeting. And I received correspondence back from the Executive Office of Energy and Environmental Affairs, Massachusetts Office of Coastal Zone Management, and the Department of Public Utilities. Those three agencies all responded similarly, acknowledging receipt of the resolution. They didn't make any comments on its substance, but they acknowledged it. The Office of the Attorney General Municipal Law Unit did acknowledge receipt of the email, but they called me and said that was insufficient. And they requested I send a physical copy, like printed, by certified mail. And I didn't know this, but that particular division of the Attorney General is apparently out of Worcester. So that was sent. And I think Mike, you confirmed that you got return receipt. I'm in May. So that's all the correspondence I have from that. They haven't sent anything on the content or that they acted differently than the rest of the divisions. They asked also specifically for a signed wedding copy of the certified vote with it, which they got. I sent all of that. That was paid for out of my own pocket as clerk, and I did submit the expense to the light plant for reimbursement, and I was not reimbursed. I was told that all expenses have to be pre-approved by management, and that was not. So I do ask to be reimbursed for the $14 and some change, whatever it is, but I did what the board authorized me to do, so the mission is done. And that's the latest. As I get any additional correspondence, of course, I would report back to the board.
Are you requesting this meeting for reimbursement?
I already requested reimbursement. It's not on the agenda. I just mentioned it because 10D ended up, and I didn't know they were going to ask for a paper copy. So 10D, they were sending the paper copy, resulted in an expense. I could live without being reimbursed.
Okay. Very good. Item 11 is the public comment. I saw
Patricia.
Patricia, sorry.
I would just like to say that it makes me extremely uneasy to be called an audience. I am a participating ratepayer. I can't speak for everybody else who is here, but I doubt that we're here in the capacity of an audience.
Okay.
Thank you. Thank you.
Lisa.
Lisa Birch, 47 Walkway. I have two things. First is when the battery developers provide the information, I'm wondering if that will include information about the, and I don't know if you're talking about a lease, if that will talk about the disposal of the battery. I've had neighbors of mine talking about this. Eventually, what will happen if we purchase a battery? I think it seems important to know what will happen at the end of its life with the disposal, because if we own it, then it's a huge expense, I understand. So does the estimates include that, and will you be providing information about that too?
So with the shared savings model, there's no cost for the municipal equipment, none at all. The battery developer will install, and then after 20 years, they'll remove all the equipment. If we were to own the battery, then we would be required to dispose of or remove the battery at the end of the day. So similar to Hallwood 1 and Hallwood 2, we would have to set up a separate like decommissioning fund to make sure that we have money available when the time comes to remove it.
Okay. The other thing is, when the board speaks with the select board, apparently the next meeting, I would like you to ask the select board to please ask or direct the town manager to please provide the information that you're asking for about the grants. We did have the standard 164 system there, that information would be given to you. You could request it from the the plant manager that you supervise. The select board here supervises the town manager for the light plant business. You can't make them, and we've been told you can't demand it, you can only ask. I would ask you to directly ask the select board to do that for you. Because under the normal setup, you should have whatever information like that that relates to the structures, the facilities that you're being told may be eventually yours. And I think you have a right to that information, but you have to ask the select board.
So, let me just interrupt, Jennifer said that, Weston and Sampson, the consultant, that is developing and fulfilling the grant obligations will be at the meeting. So
My request is still the same. I'm asking that the light board, please ask directly from the select board, please request that information from the staff that they supervise, since you are not allowed to do that. They understand the situation. I just think it would be important to make it clear. They will say whatever they will say, but I think for the record, it would be important for you to just directly ask for that information and to explain why it's important for you as a board to actually have that. And under the normal governance model, you would be able to get that information yourself. That's all.
Gary,
Thank you, Mr. Chairman. Jerry Taverna, 6th Street. So speaking as a ratepayer, I like to look at root causes of issues, right? And a lot of the conflict right now has to do with the differences of opinions on a new facility versus rebuilding the existing facility. Right? And so when I look back on this, in summer, July 24th, 2024 was the first time the presentation was brought to the select board by Chris Crawford, and that presentation is available on Whole TV, obviously, but that presentation was an outline of the issues with both buildings, and the theme was 100% rebuilding each facility on its existing footprint. That changed April 2nd. 2025, and that's the first mention of a dual.
Is that about a year later?
Almost 8-9 months. It's about a month before the first town meeting where out of 37 was brought forward. April 2nd was the second presentation, and it was the first mention of the dual. So the decision was made somewhere between the first presentation and the second to change the focus. And I don't know what the reasoning was behind that, but the only thing that bothers me in this whole thing is we've been told that, and again, if you go back and look at these presentations, the light plant building has reached the end of its useful life. And the same with the DPW building. Now, I've heard the opposite from a lot of people in the construction industry, that those buildings can be obviously refurbished for a fraction of the cost of new building, which new construction costs today are just outrageous, as we can tell. I think Mr. Scobo mentioned South Hadley building a light plant at $36 million. South Hadley, so that to me is a ratepayer and a taxpayer with all the problems we're facing. I would like to see a real engineering analysis on the buildings. That to me is where you stop the whole process. Can this building be saved? And what is the estimate to save that building, remodel it, and save the bones in both places? So that's what I would like to see. I don't know if that can happen at this point, but I think that's a very important step in the process.
Gary, I think I couldn't agree with you more that it's the design of the DPW garage is looks classic, you know, for that era. And if you, I would hate to see that just be trashed for a new metal building if it doesn't happen. Especially if the analysis shows that it'd be millions or tens of millions of dollars less.
And again, mainly because if you start to add up all the big projects we're facing right now, right? Public safety, dual use facility potentially. Bringing new feed lines in. the list of projects the town of Hull is facing is very, very long right now, as we all know, so. Again, I'm looking at it from that perspective. People are already having trouble with keeping up with increased fees and taxes and everything else, and that's gonna all be borrowed money, right? And that's gonna all directly be brought onto the backs of the taxpayers, so. Or the ratepayers, basically, both.
Ellen Whitney, 115 in there. I don't know if I'm allowed to have this question. My question is for Jen. Why was nothing done, if you were advised or directed back in November for a new garage or to get started on that? Why was nothing done? I mean, is there any accountability?
Of course there is, Ellen, and I answered that question.
Can you answer again?
I think it's been asked and answered.
So,
I really don't appreciate the hostility is from you. I really don't. I don't think it's fair.
Neither do
You're
I.
a public servant
You're right.
and I'm a paying taxpayer. And I feel like I'm talked down to by you, I'm ignored by you, and I just don't think it's very fair. Why can't we be professional, kind of meet in the middle or do something like that?
We have, and I've tried very often, all the information is online. I answered your question multiple times this evening. We have the resiliency, the critical facility study going on right now. We have taken steps to find structures that would accommodate the truck. There are also financial decisions to be made relative to a new building or not, and those answers we don't have yet. And so to make financially responsible decisions, I wouldn't do that without having all the information, because that's not fair to either the taxpayers or the ratepayers. And the properties are both town properties.
No, I understand that, but it seems kind of odd to go down one road, not the other.
No, not until we have the information that we have, because if we're asking for a design of something, we need to know what those, you can't just say to an engineer or an architect, can you come look at this space and tell us what it will cost? We need specs, they design that to specifications. And without the work being done, knowing where that building should be, are the garages that are there coming down? Is the garage that's there sufficient, that it doesn't need to raise the roof? All of these questions are being vetted right now, so to spend money before we know what we're actually looking for is just not covered. And so my answer is the same as it's been, an hour ago as it is, and I don't mean that disrespectfully, but in turn, that is also, I'm also hearing from everybody as well. And so when does a different answer mean something different? I don't. So I hope you understand my frustration as well.
I don't, but
Okay, that's fair.
I have a question. Armella Beagle, Kembarma Street. You used to give a discount. All of a sudden, they stopped doing the discounts. Are people still paying on time now that you're not giving the discounts? Is the money coming in like it used to?
It's been 13 months, right? Right, yeah.
Yeah, I mean, our collections with the new system, and it's the software that's helped a lot. We're seeing great success with collections.
You still aren't taking the discounts like you were?
I
They
think
had it for I don't know how many years, 40, 50 years?
why did it stop?
the rate changed.
So,
That went away.
well, I'm not sure who asked why it stopped, sorry, I missed who that was, but the light board adopted the rate. And we did a rate study, Amway performed a rate study for the light board. And we didn't end up ultimately implementing all of their advice, but one of the pieces of advice was to eliminate that. That it basically created more problems than it solved, or something along those lines. And it was relatively small, so light board decided to fold in a rate temp. Your different rate classes for residential ratepayers, commercials, municipal, so on and so forth, but we did not create a discount for early pay like we used to. it was part of the EMIC recommendation that the board adopted in the new rate. Obviously, solar ended up being some of the things that we disagreed with EMIC on and went a different direction.
Great.
Somebody outside there can.
Is that is? Got the motion.
Yeah, the
Motion to adjourn.
on the
Well,
motion.
before we do that, I just wanna ask, did everybody get the email from Jason McCann? You sent the board an email?
Oh, I replied to his email only with the chair on copy, and there was a lot of back and forth. So I got it and responded to it, and I'd be happy to print out the entire exchange and hand it to you at the next meeting. But I view it all as a matter of
Request a
public
future
record.
agenda item for offshore wind policy discussion. I think that we could put in that in part of that discussion.
All right, put that on the next month's agenda.
Put a copy on it.
Yeah, I mean, I think that it's been pretty, I mean, we've talked about it a number of times.
Yes.
If the gentleman, it was a gentleman.
Right.
Wants to come in and ask us directly about it, it's fine. It's. What, 20 years ago?
Should it be an agenda item or?
I think you could reach out to him and invite him. And if he and his colleague that was on there agree they'll come in person, great, put it on the agenda. If not, I don't think we can speak to somebody who's not willing to come to the meeting.
Right, when it was 2010 that you probably voted against it.
Yeah.
Turned it down, was it earlier?
Yeah, I think.
2008.
$800,000 on study.
Yeah, the money was incredible. Millions of dollars.
$1 million.
Yeah, wasn't it like $5 million?
$3 million.
$3 million
On
study.
study Delaware, right?
Maybe it would be different now, but certainly it's prohibited.
I think also what he's asking us is in our portfolio with MWIN, have they invested in any offshore wind projects, maybe on behalf of, you know how we bought into Berkshire Wind? Are we gonna buy into any offshore wind when that's available? I think maybe that's what we might be asking as well.
And he expanded his request in the back and forth, and if I'm trying to remember, to paraphrase it, essentially he's asking for what is the light board's policy on renewable energy? Big picture, like when are we going to get to 100%? And he's also asked how, but further, he asked more specifics about different projects, one of which was wind, and I explained to him my personal position on wind at length, and I think that this is a long meeting and it would be best to have that conversation as the board when these reps are back to you.
Is he a member of the House Clean Energy Climate Action Committee?
Not right now,
Jason's not?
Jason's not.
Okay, I thought maybe he was, that's why he included that.
No, he copied the chair of that committee on the email.
Okay.
I move that we adjourn the meeting.
So what about next, what
Oh.
meeting, when we meeting next?
That's it. And I'm
July
not,
16th.
Oh, the joint meeting is when, I had the 9th.
June 10th. Yeah.
Then when we were gonna meet again, the one thing that's 18.
So I thought we were talking about the 16th in July.
The 16th of June? That was supposed to be meeting again, until the 16th of July.
I think it's.
So we will again. We'll do the joint meeting, and then we will meet again, so it's the 16th.
Thank you, Nick.
Thank you. Have a good night.